then oftentimes they're, oh, I'm going to need it. Well, that's a problem when they record things. They actually want to get to your audio. All right, we'll do that. I can get closer to the mic and not working. So obviously, copyright issues are something that come up often in the work that we do. When you rely on community producers, they often skirt the rules. They're not familiar with the rules. They don't understand what their obligation and responsibility is. Until you flip the coin and you say, what would you do if all of your work was pirated by somebody else and they started taking credit for it, and they're aghast. So it's kind of a very interesting situation, but it's something we certainly need to look at. I know from my experience in judging a variety of video contests, a lot of the producers, especially young people, love to pirate music. They're using copyrighted music for everything that they do without any permission, and I've always kind of held that against them. But then the creative aspect comes in and you're like, well, okay, let it go. Depends on who's running that program. So we're pleased to be able to look at this and get into a conversation, and we will have time for questions and specifics and everything towards the end of this, but we do want to kind of flesh this out and get into a good discourse about all this. So I'm really pleased that we've got Carrie Sheehan with us today, who is from the Electronic Frontier Foundation, all the way from San Francisco, and then perhaps one of the longest drive of all, out of San Diego. You did drive? You flew. Art Neal, artist from the New Media Rights. They're both experts in this subject matter, very knowledgeable. So why don't I turn it over, and Carrie, if I can begin with you, maybe just a little background about yourself and what you hope to talk to, and then we'll get into it after the intros.
Sure. So for a start, I'm not an attorney. I'm a contractor with EFF's activism team. Our activism team works on the grassroots level to educate people about the issues we work on and try to help them find ways that they can plug in and have their voices heard in important policy debates on the issues we work on. So the EFF is a nonprofit organization, and we're dedicated to defending civil liberties in the digital world. We work on privacy, freedom of expression, government surveillance, and innovation, including copyright and patent issues, through impact litigation, policy analysis, grassroots activism, and developing tech tools for people to use. We make tech tools that people can use to protect their privacy when they're browsing online, things like that. And we work in Congress and federal agencies and the courts to stand up for internet users' rights.
Hi everybody, I'm Art Neal from New Media Rights from San Diego. As was mentioned, New Media Rights is a direct legal services organization. I actually teach at one of the law schools down in San Diego, and we provide one-to-one legal services to folks like yourselves and to a lot of different folks, from artists to filmmakers to very early stage tech startups. We tend to specialize in copyright law, in fair use, so that's actually our area of specialty. And in addition to the one-to-one services that we provide, we also have oftentimes worked with groups like the EFF to try to support policy initiatives, to try to provide some evidence that supports what's going on the ground with artists and creators. Certainly large tech companies and large media companies have plenty of representation in policy debates, so it's great to have groups like EFF, and we try to support that with actual evidence that's going on the ground, those efforts. So, but yeah, we actually have, if you remember nothing else from this presentation, I would say, remember that you can reach out to us. We would say contact us button on newmediarights.org. An actual attorney and a couple of law students and an attorney will look at your question. If we can help you, we can, and we will. If we can't necessarily help you, we will try to point you in the right direction and get you somebody who can answer your question. So that's the main thing we do, is kind of a front lines, first place to go when you have legal questions in this space. And that's our job, that's our duty.
I would say on that note, we do take legal inquiries as well at EFF. You can reach our intake coordinator at Mool at info@eff.org. I have some business cards for.
And we'll go through that before everybody leaves to make sure you have all the contact resource information that you're going to need. Well, why don't we get it underway? Art, if you could begin, maybe we could go through just some of the foundations.
Absolutely. Got a presentation here. There we go. Okay, so we've got plenty of time here today to talk about copyright law and fair use, and there's also we're going to try to leave plenty of time for your questions. But we thought when we were discussing it that it'd be nice to sort of make sure to provide a baseline. I know a lot of you have experienced these issues and might be very familiar, but some folks it still might be an area that you don't deal with every day. So thought we'd just go through basics of copyright law, basics of fair use, and then some of the frontier kind of policy issues that EFF and other groups are tackling. So to start us off, I just want to, I talked about what we do already at New Media Rights. And I guess I would be remiss to not mention that, we're nonprofit, independently funded, and so we have a membership just like everybody else. And in terms of the services we provide, a little more specifics, right? I said call us or write to us. Well, why? The question, you might have producers producing shows for you and you have questions. So we do pre-publication review, which is kind of, in this day and age, it seems like so much just gets, made and just put out there. But we do a lot of work with folks who are, who are taking their work to the next level and need somebody to review it beforehand and say, can I use this content? What kind of license do I need to use this? We draft a lot of contracts, right? So with productions, you might have that question. Maybe you have people coming into the studio. Maybe you want somebody to help you create a contract that sets the expectations with your producers, right? And how clearly do you set those right now? You say, look, we want you to be, utilizing fair use where you can, but we want you to be responsible for taking care of the clearances and making sure that when you ask us to put stuff up on our station, that you've looked into that and you've done your due diligence and things like that. But we do a lot of contracts related to productions of films, to television shows, lots of releases, and one area that we've done a lot of work on over the years is takedown. So if your content is getting removed or flagged on various services, we've worked directly with YouTube. We've defended a lot of remix creators along the way, and also a lot of folks who just get copyright claims that are illegitimate against them. But we've also worked on the other side. I mean, we have worked on cases where people get verbatim, half-hour things copied directly, and we help them to understand what their rights are and to enforce their copyrights as well. So that's some of the work that we do. What I was going to cover for you, is basics of copyright. I did want to make sure I mention. We actually just put out this book. It's available on Amazon. It's called Don't Panic. I even have a couple. I'm not sure how I'm going to give them out, but I promise I'll give a few of them out. I just, this was 10 years of working with nearly 2,000 clients, and the idea was, how do you explain without legal jargon to non-lawyers what they need to know? And this is 150 pages from all the way from forming a business or company, all the way through getting a nasty letter for some, copyright or other legal issue. Lots of stuff on IP here, but you pull it off, keep it as a reference, you pull it off the shelf, it's got, it's got a couple pages on each different topic, right? So you can look up, what was that whole thing about music licensing? Well, there's a whole there's about 4 or 5 pages in there. Not overwhelming, but enough to get you knowledgeable about what you don't know, right? And then you'll know what to go and ask an attorney about. So I guess, and the larger question when you talk about copyright, it's all about this larger question of when can I reuse content? Do I need a license? And really the 3 things you have to reuse content, you can really go through this in your head. If it's not original to you, it's got to be one of 3 things. It's got to be licensed, which a license just means written permission, right? Of course, the ideal license would be a contract drawn up by a lawyer. But license means written permission, public domain, and we'll talk about what that is, and fair use. It's got to be one of those 3. If it's not one of those 3 and it's not original, then you got to be asking yourself, is it okay to use or not? Okay, so people have been reusing content for quite some time. This is an early example of content reused in the video space. This comes from 1978, I believe, or 79. It's called Hardware Wars, and I think you'll be familiar with what this is a parody of. Turn the volume up just a little bit.
Starring Fluke Starbucker, intergalactic boy wonder. Augie Ben Doggy, venerable member of the Red Eye Knights. Princess Android, interstellar damsel in distress. Ham Salad, ace mercenary pilot and intergalactic wise guy. Darth Nader, villain. See incredible celestial battles ablaze with death-dealing weaponry.
Okay. So that's 1977, but that's reuse of characters and ideas, and it's a parody. It's obviously fun and it's silly, but there's lots of ways people reuse content, right? It could be to make a parody, or it could be important political speech, right? There's lots of reasons why folks might want to reuse content, but a lot has changed along the way. Some hasn't, but some has, and I'm going to ask you after this what you think has changed. So here's an example from just the last month. This is DJ Earworm. It's on YouTube. It's called the United States of Pop 2016. He does one every year, and it's a mashup of all the pop songs from the previous year.
The whole year put you in the worst mood. It's hard sometimes to put you out. When you hear the song, if you really listen, when you hear the song, that's when you audition. Cause we all get lost sometimes, you know. Through the darkest of days, it's how I learn how to go driving the planet. Think we're losing our mind now, yeah. Shouldn't be fighting on your own. So if it's something haters, baby, take control now. Play that music too loud. Let's be you don't easy. Welcome to my house. Welcome to my city. Welcome to my home. Make it feel like the good old days when we in our sound. Welcome to my radio sound.
Okay. So that looks pretty smooth. It looks as if it's almost one production, but it's obviously taken from many different songs, many different videos. You can argue about the legality of what they reuse or not, but the idea is that folks have been building upon what's come before for a long time. So what has changed between 1977 and today? What would you say are some of the big things that have changed in terms of production?
Production quality.
Okay, production quality, obviously, and the cost of producing. Believe it or not, the Star Wars production might look fairly simple, but that cost quite a bit in the 70s, and I think it even cost them $15,000 or $20,000 to do, which obviously I think it might not take as much today. The availability of cameras and editing equipment and everything so affordable. I mean, we even produce things in-house, and it's just and you can produce high quality things with much less resources. And then obviously the other thing that's changed is what? I mean, that definitely, the graphics goes to the quality of the whole thing. But,
availability of content.
right, the distribution, right? So it's so easy now it's so much easier, so much cheaper to distribute these things that obviously, it becomes a situation where, before, I guess if you're trying to access that hardware wars, it might have been on a Betamax or VCR tape that's given to you at some kind of a swap meet or something like this, or some kind of convention. This now can go out to everyone in the world and instantly. And so these copyright issues come up every day. I mean, we see it every day just in terms of interacting with memes and other things. It's just so easy to cut and paste. So it means copyright law is called into use every day. So what's copyright law all about? Well, first of all, it protects your work. It protects all sorts of works from being copied by others or reused by others, with some very important exceptions like fair use, that we'll talk about. But on the other side, copyright law protects everybody else's work. So that when you see a photo out there that you like, or a video, or a book, or something like that, that you can't necessarily just borrow it wholesale without permission or without some reason, under fair use. So it reminds us that the outputs of creativity, they end up being inputs for the next generation of creativity. And so copyright law, it's definitely an argument about how balanced it is, but copyright law sets that balance, and it says how much can the next generation of creators sort of borrow from and build upon the previous generation. So 5 main rights you get under copyright law, right? Right to reproduce, that's just the right to make a copy, right? That's a very basic right to just make the copies. And then you also are the sole person in the world who can distribute the work, right? So that doesn't just mean to sell it. That also means maybe even through a file sharing network or something like that. There's a lot of ways to distribute, and it doesn't necessarily mean just selling the work. You're the only person in the world that can create derivatives. So, Harry Potter 1 through whatever, J.K. Rowling is the only person who can create Harry Potter 15 or 20, and the only person who can authorize a movie to be made off of those series of books too, right? Derivatives are adaptations of existing works. And you're also the only person in the world as copyright owner that can perform or display the work publicly. So you get those 5 rights, and it lasts for life plus 70 years. Right? So if my toddler draws something at the breakfast table this morning, it's life extending technology, we're probably talking 300 years from now, right? It's gonna go into the public domain. But that stuff lasts for a very, very long time. These rights last for a very, very long time. And to just clarify what's protected, it's all about protecting expression, not ideas and facts, right? So yes, books, movies, scripts, songs, comic books, musical compositions, sound recordings, photographs, and all those things in the digital form, they're all protected. But remember, the key thing to remember is that copyright protects creative expression, not ideas. So if you want to write about the fact that the mayor of Fresno came here and spoke today, you're welcome to do that on your blog, right? But I'm also welcome to do that. Just because you put that article up first does not mean you have some sort of monopoly over the writing about that. That makes a lot of sense to us. Obviously, in a basic speech context, you have to be able to speak about these things. But it's also what, the fact that an idea is not protectable, that's what allows you to have 3 or 4 movies about the same topic. Right? I don't know if everybody remembers, but there was a couple movies made about Muhammad Ali's life, right? Just because one person makes a film about Muhammad Ali's life doesn't mean somebody else can't, right? So, but if that person borrows, wholesale large pieces of that film, then we might get into an issue. I think helpful to understand what copyright protects is to think about what's not protected, right? There's ideas and facts aren't protected. Titles, names, short phrases could be protected by trademark, but not copyright, okay? Federal government works aren't protected. This is really great, I think, particularly important for community access stations to know, which is that, and there are wonderful archives of this, like on archive.org and things like that, but the federal government works, and that gets a little complicated because a lot of times our federal government hires people to make things for them, and so if they're licensing it, then maybe they can't give you the right. But for the most part, photos from NASA, World War II, and propaganda, things like that, there's a lot of content that is totally in the public domain. Presidential speeches or inaugural speeches, might be in the public domain. So there's a lot of things that might be available as federal government works that are public domain immediately. States actually can hold copyright, so that's good to know. Different state agencies have different approaches. California state agencies are pretty open. They have content policies usually on their site that say you can use it for this or that. But federal government is public domain. Numbers, processes, and systems. Processes and systems could be protected by patent, but not copyright. And so at least one thing hopefully you walk away with here is you'll be able to know, you're out somewhere, you can differentiate, right? Trademarks is all about consumers not, knowing where this good is coming from. It's all about source identification. Patent is all about inventions. And copyright is about what protects creative expression, right? Okay, so what does it mean for you and your works? Well, you have the copyright to any work you're creating, right? So if you're creating the original work, you have all those rights I talked about, and they're yours to license, they're yours. You don't have to register to get protection, but registration can be quite important if you ever have to actually enforce a copyright. To be honest, my experience over the years is that when folks get their material wholesale infringed, copyright attorneys just won't even speak to a client unless it's registered. Because with registration, you can get attorney's fees and statutory damages as well, which can run up to $150,000. And so if it's willful. And so I think that if you have something that's really important to you, a very valuable piece of content, it's a smart thing to think about getting that registered. And you can do that yourself. You can't, a trademark or a patent, you really need to go get an attorney for that, but you can register a copyright if it's something you really want to protect. You can usually protect it for quite reasonably at the electronic copyright office online. So when you upload to YouTube or Vimeo or Instagram, what do you give them? Sometimes people say, oh, well, they own your stuff, right? No, but they don't typically own your stuff. You're giving them what's called a non-exclusive license. And that non-exclusive license means they have the right on YouTube to display and to show it and to be able to embed it other places. But you can also take it to Facebook and other platforms and use it there. So that's what you're giving, is a non-exclusive license. And that's your right. Once you have that content, you're allowed to license it out to folks. And if you think about something like a film, people often, and we have a whole chapter on distribution in our book, but if you think about something like a film, you don't have to give all those rights. A lot of filmmakers, we work with a lot of social impact documentaries, they might work with a distributor in the United States, right, or a distributor internationally, and they say, you have the right to distribute my film in the United States, or in this set of countries, right? And then it's just that right for just that region. So you can really customize a license to give up certain rights. And on the other side, though, and this is for all the productions that you're doing at your stations, at your channels, I mean, this becomes really, really relevant here. You don't have the basic copyrights to audio or video or images that are used from another source. And so you've got to have one of those three things I talked about, either written permission, either be in the public domain, or be an example, be fair use. So ownership, I just wanted to quickly touch here. Usually it's the author-creator that's the owner, but it's not always, right? This happens a lot with musicians and record companies. Record companies often will own what the musician created. There's a famous story of somebody trying to get license for The Simpsons from Matt Groening, and they had to go through, Matt Groening said sure, and then he sent them, somewhere else to Searchlight, and then Searchlight said sure, and then they finally sent them to the right people at Fox that actually owned the work, and they said, well, 10,000 per second. So you just have to make sure you're finding the correct copyright owner, not getting permission from the wrong person. Sometimes the author or artist is not the owner of the copyright. Couple notes here. Only the copyright owner can claim infringement. That's really important. A lot of people online will like to bully people and say, that's taken from whatever. If it's not the copyright owner, that has no teeth, and it really doesn't have to, it's really supposed to be the copyright owner enforcing their copyright claim. Third-party threats aren't enforceable. Talked about the fact that the owner might not be who you think. I talked a little bit about non-exclusive licenses, and of course an assignment is when you give the rights to somebody else. An exclusive license is when you only let that person exercise your copyright rights. And then a non-exclusive license is you let that person exercise your rights, but you can go anywhere else and exercise those rights as well. Just a few notes about getting a license. Generally, you have to go directly to the copyright holder and negotiate with them. And I think it's really helpful to go into any of those. We work with a lot of filmmakers, doc filmmakers getting licenses. And it's really nice to go into those negotiations telling folks exactly how you're going to use that material. Because a lot of those offices, especially at, let's say, like a recording company, there's a song you really want to use, they're often pretty slow to get back to folks, unless they're maybe at a big studio or something. But you can really help yourself on a license. If, let's say, you're reaching out to BMG Chrysalis, which is part of the recording company at Sony. It's one of the recording companies. And if you reach out and you say, look, I want to use 25 seconds of this, I'm going to use it in the opening credits, I'm going to be streaming it, I'm going to be using it at film festivals, the response will be so much more so much quicker than, hey, I was hoping to use this content. So you really want to be clear with folks if you're asking for a license, how you're going to be using that, and then they can work out with you what that license is. But I also don't want to miss, and I know we might not have a ton of time to talk about Creative Commons, but Creative Commons and other openly licensed music, photos, video are all over the internet. I mean, just as I know Flickr isn't that as popular anymore of a photo site, but they still have a repository of 100 million plus Creative Commons images. And I'd encourage you on your productions to encourage your folks to look for openly licensed photos. And it's usually pretty darn easy to utilize those licenses. You just need to give attribution. And the licenses vary, so it's not as simple as just if it's Creative Commons, you can use it. But as long as you find the right license, you can use it with basic attribution. And there's a lot of great sites. If you're ever looking for background music, right, on a production, there are some really good sites. But one of my favorite is Incompetech. I think he does a great job. This is Kevin MacLeod. You'll see his stuff all over YouTube. If you watch the end credits, you'll see people credit him a lot. He's very clever about how he did his site. You can go to the site, Incompetech, and you can really be very specific about the genres that you want of music, and then he allows you to either reuse it for free by just citing him, or you can pay, I think it's $35, but he might have changed the price, and you can use it commercially without attribution. So if you ever had trouble with music, because music is a real challenge, if anyone's ever messed around, because music is just, you've got so many layers. You've got the musical composition, and you've got the sound recording. That can be a really great source for music in your productions. And there are other sources as well. I guess I'd mention that on our site, on our guides page, newmediarights.org, if you click guides, there's a guide called How to Find Images, Video, and Audio to Reuse in Your Own Work. And that has we must have 30 or 40 links on there of different sites that offer openly licensed work. So I would check that out if you're interested. As I said, music can be a bear, and it gets even more complicated with you all because a lot of you are probably have a relationship with the cable operator, right? And the cable operator has some sort of blanket licenses with ASCAP and BMI, which you might know about. My comment there is to just, if you're not familiar with it, sit down and understand what that license covers and doesn't cover. I know I don't deal with that every day with those stations, but I've definitely dealt with our local PBS station separately. I know they don't do the public access, but they have a relationship with ASCAP where they get sort of a minute. They can play a minute, and I guess what's important to know is that they only cover certain things. If you have the ASCAP license, great. You have what's called the performance license. But once you sync that up with video, you need something else called a synchronization license. And if you're using the actual sound recording, you might actually need what's called a mechanical license. And I'm not trying to overcomplicate it, but that unfortunately is still the level of challenge with licensing music out there. And as I said before, whenever you're trying to get a license for music, because frankly, when it comes to fair use, music is treated differently a lot of times by courts, and if it's really just aesthetic use of music, you're probably going to need permission. So at that point, like I said, you want to be really clear that with the recording company, with the publisher, that we're using it at festivals, we're doing streaming, we're doing DVDs, these kinds of things, so they can give you the right license that you need. Otherwise, if you don't have a license, it's got to be in the public domain, which is most things before 1923, although not everything before 1923, because there are some special issues with sound recordings, but most things before 1923, to simplify just a little bit. And then also, if it's not public domain, your only other option is fair use. And so I want to do just a few minutes on fair use here. So fair use, it's all about a safety valve. I just told you that these rights last for life plus 7 years, and who knows what Disney's going to lobby for in the next couple of years, and it might hopefully it doesn't push beyond that. But it's all about, it's a safety valve to that monopoly over content. And so it allows you in certain contexts, in certain situations, to reuse content without permission. And the importance of fair use cannot be understated. In the last 15 years, it's really come back. There was a situation, for a long time where you had many fewer content providers and they had big legions of lawyers who could just get everything licensed. But as you see every day, all these stuff on YouTube, they don't have lawyers. They're putting stuff out there. They have to be knowledgeable about the law in the same way we're knowledgeable about the rules of the road. So it's about criticism. It's about commentary. It's about parody. It's about things like these two examples. I'd like to just show two examples because I think they give you the context for what fair use is. The first example here is called Buffy versus Edward. This is from a remix creator from your neck of the woods, San Francisco, Jonathan McIntosh, and he's been a client of ours at New Media Rights, and I'll play that for you here.
Not late for the bell rings. Uh-oh.
Sex. The sex drive in the human animal is intense.
Hello,
Of course, for teenagers such as yourself,
I'm Edward Cohen.
with all sorts of hormones surging through our bodies, compelling you to action. Among teens, pregnancy is the number one negative consequence of sexual activity.
So, spill. What was that all about?
Nothing serious, I think.
It looked like more than that to me. He got all googly-eyed.
Survey says vampire.
I'm sorry, I'm just trying to figure you out. You're very difficult for
I'm
me.
the Slayer. Slayer. Chosen one. Look it up.
Okay, so that's the first example. That's kind of a newer example. There's nobody commenting directly, but it's the juxtaposition of those two works, and maybe some of you recognize there was Buffy the Vampire Slayer juxtaposed against the Edward character from Twilight, and it's basically it's a critique of Edward and as kind of a stalkerish, lurking character, and so in that way, the artist is doing some really important things that make it fair use, which I'll talk about in a minute. But a more traditional example is this documentary film from a client of ours, Michael Singh. And this film is called Valentino's Ghost. It covers about 100 years of Western media depictions of folks from the Middle East. And so to do that, obviously, you just cannot do that without news footage and film footage and things like that. So you can see from this trailer an example of what it takes to do a documentary film like that, and it takes a lot of fair use. Oh, maybe. Let's try again. There we go.
Where do these images come from? What is the relationship between these images and American foreign policy?
America's love affair with Arabia reached a frenzy with The Sheikh, starring Rudolph Valentino, because it was represented as a place where there was a lot of romance and excitement.
What ended America's love affair with Arabia was actual contact. The British Empire invaded Egypt and Palestine. In the media, the Arabs, not the British, were the attackers.
The mainstream media presents a rich diet of pictures of Palestinians blowing up targets in Israel.
I was watching the news and Walter Cronkite said, Jerusalem has been liberated. It had been liberated from whom?
What you do is you change and diminish the language of the conflict. The wall becomes the fence or the barrier. The occupied territories becomes disputed territories.
The television coverage of the Iranian hostage crisis dwarfed the coverage of the civil rights movement and even Vietnam.
Day 13.
It was the obsession of American television news for more than a year.
United States goes into the country promising democracy, freedom, liberation. And we see these very graphic images of what the American experience had come to.
Somehow along the way there, we had produced the image of the beast human in Arab form.
Okay, so you can see there a wide variety of different reasons why you might need to utilize fair use, right? Various reasons why you might need to call upon fair use. And the whole trick to fair use is the 4 factors. And you start with factor number 1. You have to look at these factors. And if you forget these or have trouble with these, the thing to remember is we have a fair use app that we built on our website at newmediarights.org/fair use. But the first question is it commercial or non-commercial? If it's commercial, it's a little bit less likely to be fair use, but that's not a determinative thing. And that exists on a spectrum. If you're selling it, obviously it's commercial. You're selling access to the work. It's obviously commercial. But if it's a nonprofit educational use, then it might be a little bit more on the other end of that spectrum and helpful to you. The key inquiry on all 4 factors is the transformativeness, right? Think about those films, right? The original purpose of some of those films that appeared in Valentino's Ghost. Those films were intended to be entertainment, right? In the 20s and 30s, they were entertaining films. The filmmakers using that in a very different context to try to show over time in sort of a collage what those representations looked like. And so it's a very different use than the original use. And so you think about how was the original thing used, same with the Twilight film, right? The Twilight film is entertaining, pop culture, vampire fiction, you can go watch it or read the books, but then the video that Jonathan McIntosh creates there is really much, much different and intended to sort of be critical of that character. And so transformativeness is key, and you can physically transform it. You can also you can physically transform it. What I mean there is Jonathan used many different scenes from both Buffy the Vampire Slayer and from Twilight. And a lot of those scenes are not the full shot. He actually sort of zoomed in to try to make the shot feel different for what he was trying to do. And so you can aesthetically change things, and you can also change the purpose of them, which I think both videos give you an example of. You then look at nature of the original work. So first you looked at what was your use, why were you using it? And now you look at what is the original work. This is where I say on this factor, it tends to not be determinative, but there's a couple things to remember. If it's music, it tends to be highly protected. It's different when we see news articles. We're so used to people quoting other news articles, and that's really common in print. But when it comes to music, we're not as used to quoting. It's actually sampling. There's a lot of cases that are pretty rough on sampling music. And so what you might think of as a short quote or sample of music being very similar to a quote of words can be treated very different under the law. So documentary films and nonfiction works are going to receive a little less protection and be more likely to be fair use. Fictional works like music and fictional literature tend to get a little bit more copyright protection, but the main thing on this factor is unpublished works are very much protected. So if somebody's trying to review a film that they got their hands on before it ever got put out, that's a big issue, right? It's courts try to protect the author's right to first publication. The third factor is really important too, and this is where people have a lot of misconceptions, I think, where it's like, oh, you can take 10% or you can take, 20 seconds or something like that. There is no general rule about percentages or seconds. It really has to do with a couple different ideas. You want to, obviously, the less you take of the work, the better. Obviously, the less it makes up of your final work, the better. But also there's this other issue of heart of the work. Did you take the heart of the work? And courts look at that, and that's a much harder thing to sort of prove. And there's a famous example where they took 300 words of a 300,000 word biography of Gerald Ford about why he pardoned Nixon, and that was still considered to be infringement and not fair use. And part of that was also because it was unpublished. But it's a more complicated decision, and a lot of it hinges upon transformativeness. And you can see how the less you use and the more you comment on it or change it or add new audio to it, commentary over it, the more likely it's likely to be transformative. So you can see how the amount taken fits in with transformativeness. And I know this is a lot with copyright and fair use. It's a lot of information, and so there's a lot of guides on our website and in the book to kind of, if you want to revisit this. We even have video. We even have video courses on our YouTube channel that you can look at as well. It's about we have an hour-long course on copyright on there. If you didn't get enough copyright today.
How much of this content is in the book?
There's a lot of this, and we go into a little bit more detail. And I can also make these slides available too to you guys. I'm happy to do that.
Oh, that'd be good.
And the last factor, though, is market effect. Okay, and I'll leave it at market effect, which is, it's about, can people come to you as a substitute for the original, right? Instead of buying the song on Amazon or iTunes, can they just go on your YouTube channel and listen to it? That kind of thing, right? If it's a direct market substitute for the original and there really isn't much transformativeness, you've probably got a copyright infringement issue on your hands. So those are the 4 factors, and I'm glad to discuss more after we talk about it.
Thank you, Art. That's a lot to digest. Take a deep breath. And I'd like to turn it over to Carrie.
So I'm really happy that Art went through all of the basics of copyright law and fair use with you guys, because that means I can talk about a couple of weirder things that are closer to my heart, or are close to my heart. So first, I want to get a sense of how many of you distribute your content online through platforms like YouTube or Vimeo. And have you ever received a takedown notice for any content you've put online? Great. So we're going to talk about the aspect of copyright law that kind of governs that system. That's Section 512 of the Digital Millennium Copyright Act. And we're going to talk about another law, Section 1201 of the Digital Millennium Copyright Act, which also rubs up against fair use in the digital space. Now, speaking hypothetically for an anonymous friend, have any of you have an anonymous friend who's ever broken encryption on a DVD? Yes, great, excellent. So that's going to implicate that law. But first, I want to just touch on the relationship between fair use and the First Amendment. So our cultural landscape is flooded with the copyrighted works of others, and when we want to engage with culture actively, or comment on culture, or report on events, we're often needing to make use of other people's copyrighted works. And they become really critical aspects of our ability to freely express ourselves. And the Supreme Court has recognized that your right to make fair use of other people's works is a right that's protected by the First Amendment. In a couple of cases, Golan versus Holder and Eldred versus Ashcroft, the Supreme Court said that fair use, along with the limitation on copyright law that says it doesn't protect ideas, only expressions, that those two things are part of the contours of copyright law that make it compatible with the First Amendment. Otherwise, copyright holders would be able to exercise greater control over other people's speech than is justified or than it's compatible with the First Amendment. So when we're talking about trying to protect people's rights to make fair use in their content and trying to protect platforms' rights to host those fair uses, we're really also talking about the importance of protecting people's rights to freely express themselves in a world that's full of copyrighted content. So I also want to mention, fair use is a case-by-case analysis. We go through the 4 factors with Art, but there are some more easy cases. There's best practices for a lot of those cases. So a lot of cases, journalism and reporting are going to be clear-cut cases of fair use. Non-commercial remixes are going to be clear-cut uses of clear-cut fair uses. But even when you're making a really clear archetypal fair use, you can still get sued. You can still get a takedown notice. I wanted to provide just one quick example. There was a case out of Inglewood, California in 2015. In that case, the city of Inglewood sued a resident for posting critical videos that included videos of a city council meeting on YouTube. The city council videos were likely in the public domain under California's Public Records Act, and the videos were really clear examples of fair use. He's using small excerpts of the video, he's providing a lot of criticism and commentary, and the reason the city sued him is because it made the city look bad, it made the mayor look bad. Fortunately, he fought back and he won, but it's an example of how often copyright gets used as a tool of censorship, both through copyright lawsuits as well as through takedowns filed against copyrighted works on online platforms. So rolling right into the Digital Millennium Copyright Act and Section 512. Section 512 provides certain safe harbors for online service providers. So there's some safe harbors that apply to online service providers or internet service providers who provide conduit services, like internet access providers. There's some safe harbors for search and indexing services, and they're safe harbors for user-generated content platforms, which is what we're really going to focus on. And what I mean when I say safe harbor is that they give an area of protection to those platforms against liability for the copyright infringing acts of their users. So if I post a copyright infringing video to YouTube, as long as YouTube complies with certain statutory requirements, then they are not going to be liable for my copyright infringement. And those requirements are that the platforms comply with a notice and takedown regime that's described in the statute, which means that they have to have a registered DMCA agent to receive notices of infringement from a copyright holder. They have to respond to those notices by valuing the content and taking it down. And then they have to give me an opportunity to file a counter notice, and if I do, they have to reinstate the content. So I'll break that down a little bit more. The way the system works, it incentivizes the platforms to take the content down, because if they don't take a content down on receiving a notice, they can face a lawsuit from the copyright holder. They'll lose their safe harbor. But there are important user protections built in. So I can, if my video is taken down off of YouTube, I can file a counter notice that requires them to replace my content after a waiting period of, I think, 10 to 14 days, unless the copyright holder files a lawsuit. And those safe harbors are super important to making sure that those sites can continue to host user-generated content, as well as safeguarding people's ability to make fair uses. But now, because it's kind of biased against the users who upload content and biased in favor of the rights holders, because they have an incentive to take content down to avoid the lawsuits, this means that a lot of platforms will remove content that is even very clearly a fair use in response to a takedown notice. And increasingly, large rights holders are using automated systems to send kind of thousands of takedown notices to online platforms, often targeting just the words in a title, for example, so not doing a really careful analysis of whether the content they're targeting is fair use or not. There's one great example from a couple years ago when the film Pixels came out. The studio behind that film sent takedown notices for pretty much anything with the word pixels in the title, including, in one example, a YouTube video where someone was reviewing a digital camera. And there was another great example of a fair use on YouTube that was affected by a takedown notice. This artist, Dylan Marin, creates a series called Every Single Word, where he takes popular Hollywood films and edits them to only feature the words spoken by actors of color in the film. So it's every single word, for example, in Gone with the Wind. And for that particular video, Every Single Word in Gone with the Wind, he received a takedown notice from the movie studio, probably based on the title. That content was eventually replaced, but only because there was a large popular uproar over its takedown, and the studio backed down from the request. The user protections in Section 512 and in these safe harbors aren't as robust as we would like, but they do provide certain protections. The counter notification and replacement process is critical. There's also a portion of the statute that requires that, and we've had a recent ruling from the Ninth Circuit in litigation that EFF's been involved in for the last almost 10 years, that requires the person who sends a takedown notice for copyright infringement to consider whether or not the content that they're targeting is a fair use. And if they don't consider whether it's a fair use, they could be subject to a lawsuit for financial damages for the people that are harmed by that takedown. The ruling out of the Ninth Circuit is in a case called Lens versus Universal Music. It involves a video of a dancing baby and a Prince song. The ruling from the Ninth Circuit, it wasn't as great of a ruling as we'd like. It applied a subjective standard to the inquiry about whether or not the rights holder has considered fair use, which in legal terms, if someone has to consider something but only has to prove that they considered it subjectively, it's not very protective. They could be objectively unreasonable in their subjective belief that something wasn't a fair use and still get away with it, which isn't very protective in the long run. So we've asked the Supreme Court to weigh in on that and to correct the Ninth Circuit, because we think what Congress really intended there was something to be more protective of users. We're also seeing in this space some troubling developments that further jeopardize fair use. So we're seeing a big push from the big copyright industries, the big content companies, Hollywood, the RIAA, the MPAA. We're seeing a push to require platforms to implement content filtering technologies. And we're seeing that push coming in two different ways. We're seeing it through private agreements that take place in kind of secret backroom negotiations between the large internet service providers and the large copyright holders, and we're seeing it at Congress and at the Copyright Office. So one example that you might be familiar with is the Content ID filter on YouTube. So a lot of content that you upload on YouTube gets pushed through the Content ID filter. If it matches content that's registered with that filter, it gets flagged. The content owner can decide whether to block the content or whether to kind of make money off of your use of their content, even if your use is a fair use. There's a problem with the content. There's a lot of problems with the Content ID system, and people have different complaints about it, but I think for our concerns here is filters like Content ID and other automated filtering systems aren't capable of making the nuanced fair use consideration that's necessary to make sure that completely lawful protected speech on online platforms doesn't get removed or filtered out. It can't, for example, tell whether a full-length copy of something is a lawful educational use. It can't tell whether the music used behind something, if it matches the filter, is being used in a way that's critical or that's juxtaposing it against other compositions in a way that makes new meaning, right? It's not as capable of humans of making that kind of analysis. But they're pushing to implement these requirements across the board, which would require kind of all online service providers, all user-generated content platforms to use some kind of content filtering technology, or at least all above a certain size in some of the proposals. And this wouldn't just be a problem for that platform, for you trying to upload your content to those platforms. It's also a huge problem for competition in online platforms. So maybe you're sick of using YouTube and you want to use another way to distribute your content, or maybe you don't like YouTube's policies, you want to use another site to distribute your content. If every site has to implement a very expensive filtering system, it's going to reduce the number of sites that can provide those kind of services. I think Content ID costs YouTube something like $65 million to develop. Does that sound right? I think.
Who knows how much to administer too? They have an entire office in South Carolina, so just working on it.
Yeah, so it's a huge amount of money. And smaller and nonprofit platforms just can't invest that amount in developing and implementing those systems, nor can they do the kind of human overview that would be necessary to comply with obligations that would be influenced by filtering. So we've been fighting against that largely in a process that's unraveling at the Copyright Office. The Copyright Office has undertaken a study on this area of the law, requested public comments. We've been participating in several rounds of public comments and in public hearings, kind of fighting against these ideas that would require kind of a global application of copyright filtering. I told you I was going to talk about Section 1201, so I'm going to talk really briefly about that before we open up to comments, unless anyone has questions yet on this part. Okay, so another part of the DMCA, Section 1201 of the Digital Millennium Copyright Act, makes getting around or circumventing the digital locks or digital rights management that copyright owners use to control access to copyrighted content. So for example, the encryption on a DVD. It makes it illegal to do that, and anyone who does it could be subject to pretty serious civil penalties, and in some cases, criminal penalties. The law was initially designed to target circumventing or breaking digital locks for the purpose of copyright infringement, to get around people kind of cracking encryption on DVDs and then putting those DVDs online for anyone to access. But the language is written broadly enough that it can apply to, and has been applied to, circumventions of digital locks for the purpose of fair uses. So cracking the encryption on a DVD in order to take a video clip that you're going to use in your documentary or in your non-commercial remix. It's caused a lot of problems for a lot of perfectly legitimate activities, even outside of the media space. It's a huge problem for security researchers, for example, who want to test Internet of Things devices and look at software inside your devices. When Congress drafted the law, they recognized that it would have this broad effect on a lot of lawful activities, and they wanted to limit that. So they put into place a process through which every 3 years you can petition the Librarian of Congress to grant you an exemption to break certain kinds of digital locks on certain kind of content for certain purposes. It's called a triennial rulemaking process. It's extremely arduous and often requires lots and lots of hours and lots of lawyer hours, and is really inconvenient. And the exemptions at the end are often really limited in their usefulness, and then you have to ask for them again every 3 years because they're not permanent. But in the last round in 2015, EFF, along with the Organization for Transformative Work, fought for and won an exemption to break the encryption on DVDs and Blu-ray discs for non-commercial video remixes. And some other folks who, like documentary filmmakers, won an exemption to crack encryption on the same media for documentary films. It's great to have those exemptions, but they are really limited in terms of what they cover. So we've been pushing really hard for this law to change because of the kind of wealth of variety of unintended and harmful consequences that it has on legitimate and lawful speech. We are currently engaged in litigation with the US government over this law because as I said at the beginning, fair use is also, it's also protected First Amendment speech. And to the extent that this law limits your availability to engage in protected First Amendment speech by keeping you from being able to engage in lawful fair uses, it should be understood as unconstitutional. We're representing a security researcher and someone who's made a tool that's useful for video remixers in a lawsuit over that law, but we're also pushing in Congress for legislative reform. There's been a few bills introduced that could reform that law by limiting it to only those circumventions that are for copyright infringing purposes, so excluding circumventions for lawful purposes, like the video remixers and the DVD video remixers and documentary filmmakers. So that's a kind of area that we're trying to mobilize people for and get a lot of support for trying to fix that law and for trying to preserve these online safe harbors and fight back against proposals to filter online content. Do you have any questions?
Well, let's get it started first. Most of us are the broadcasters, and we have clients who are the producers. Where does that liability extend if I'm the broadcaster, or am I safe because they signed the submission form that says I've got all rights and permissions?
Well, I was going to follow up on what Carrie was saying about 512 to kind of touch on that. Just, I mean, I know that locally with Media Arts Center San Diego and then out in Denver, I know Denver Open Media, they have a lot of, even a lot of you probably have your own sites and services and are distributing this content online as well as through broadcast, right? So there's your moment where you might become a 512, Section 512 service provider. And so at that point, there's a time where you could reach out to us, for instance, and we've done terms of use, privacy policies for folks. And in those terms of use, we do all the right things and help you understand the business processes of how to deal with takedown notices and how to deal with counter notices. And so, yes, you might become a 512 service provider by just putting the producer's content out there. And you might want to utilize that safe harbor because you might have all sorts of producers doing all kinds of great stuff, but maybe it's really, really tough, just like it's really tough for YouTube to look at every single darn video that comes through. And then you can utilize utilizing the safe harbor is really, really smart because there have been some really bad sort of copyright trolls over the years who go after folks who don't have the DMCA safe harbor. And so yes, you could help limit your liability through DMCA. You could help limit your liability through having a good terms of use. I know for a lot of community groups, we work with one of our clients is a literary arts group that does these radio shows and live performances, things like that. And every month they get submissions, right? And so they have a contract with those people. It says like, this is how we're going to treat your submission, and you're also agreeing that it's original to you or that you have the rights, that you need to use this. And so it is important, I think, as a center for this media coming through, and so much might be flowing through you that it's hard for a small staff to really review this stuff, and you might not want to even get into that business anyway. And so there are a lot of ways to think about protecting yourselves. 512 is definitely one of them.
I would add to that too that the 512 safe harbor is often contingent on the user directing the uploads of the content, right? So if it's your website and you're uploading all the content, you're likely not eligible for the 512 safe harbor. But if you operate a site where your producers can upload the content, you might be more likely to come within the safe harbor. But that's definitely a question for an attorney.
Right.
It's very basic, and it has to do with talent releases.
Got it.
I do a whole bunch of interviews out in the field, and I'd like you to comment on written versus verbal on-camera talent release, and if it is an on-camera talent release, it's considered legitimate. how extensive does that have to be, or should it always be enough?
You know, number one thing with talent releases and with any releases, but that's not just, you know, it could be a interviewee for a documentary. The number one thing with a basic video release is notice to that person how their image is going to be used. So you can't be representing that it's going to be used one way and then all of a sudden it appears on a commercial, this kind of stuff, you know what I mean? You've got to be, the clearer you are with them, both on the agreement and what you say to them, that's all important. And so obviously the best way to do it is to get a written permission. One thing I'd say about talent releases and or video releases, as I call, you know, interviewee releases, there's a lot of people go out there and just grab contracts off the internet, and it's true that a video release is one of the more simple contracts, but I'll tell you that you can really kind of mess it up just by thinking, okay, this is going to do it for me, because it's not an engineering project. It's not, this is the tool for the job. It needs to be tweaked. It needs to be made specific for you. And what I mean by that is a lot of talent releases you might find from 10, 15, 20 years ago say, I am getting this recording for purposes of this documentary, right? The truth is that a lot of the people we work with who create content, it's amazing the different things. They might create a documentary that's feature length. They might create a 50-minute version for PBS. They might create a 6-part series that they put online. They might do an HTML5 site with all the basic, you know, the 10 hours of video. So you want to be clear with people. It's going to be used in a variety of ways, and how it's going to be used. If it's going to be used in commercial, in terms of the trailers and promotional materials, they need to know that. Written is best. If you're doing it by video, and people certainly, you get into situations where you have to do it by video, my main advice there, it's always plan B there, but if you do, it's all about notice of how it's going to be used, and you want to have that clear.
Record that as well.
Yes,
What you're telling
that's
me,
right.
and they say you have my permission.
Yes, exactly. But and we could talk about that in specific instances, and it's not the ideal, but I'm just, you know, you really can't just have them saying, sure, use my likeness kind of thing.
We have another right here in front.
So I live in a few counties north of here. I work for the County Office of Education. We operate the tech channels in that county. We also have a video production crew. So we're making educational content, a lot of student events. My goal is to get as much of that on the air and really get our local stuff going. We have a lot of submissions from our schools, from other educational organizations. Our biggest problem is music. They always want to have a popular song in there. So I can't use it. I can't put it on the air. I won't put it on YouTube, and we won't share it on social media. Can you talk about some ways around that, or ways to work with those organizations? We don't, you said ASCAP, and what was the other one?
Sure, BMI.
BMI, we don't subscribe to any of that.
You know, that's the kind of thing where I think you could come to an attorney like ourselves and really discuss a strategy for dealing with that. Figuring out what are the main things that you need and who might provide it. I mean, there have been some really cool innovations in music in the last couple of years. They're not quite there yet, but there are a few sites that help with part of that. Unfortunately, nobody's figured out the whole basket yet of rights. So, for instance, if it's a performance of a song, right? There's a really great, there's a couple of sites, even Louder, for instance, does a great job of helping you if you were going to have somebody cover a song. They do a good job of getting you the basic rights for the audio version of that. The problem is, as soon as you sync that up with video, it's a different set of rights that you need. There's also a site called Song Freedom, which provides some really, really nice ways to license for streaming purposes online. So in other words, you could find a song really easily on there, pay a flat fee of a couple $100 or something, and you get to use it. Unfortunately, I don't know that it always extends to the broadcast piece. So, you know, I think though that it's something where if we look through and figured out what is it that you're really trying to do, maybe we could reach out to some of those entities. And I think describing to the various entities what you're doing is really important, because I notice when I go with documentary filmmakers to get a music license, it's, you know, immediately, especially, I mean, we're in San Diego, we're not in LA, but they're like, oh, you're in Southern California, so you must be, you know, making some huge production, have this huge budget. Not true. But they assume immediately, and they're like, well, you're gonna have to pay $50,000 for this license. And we just try to be really clear with them, like, this is how it's being used. It's gonna be at a few film festivals, it might have a little bit of online distribution, it's a niche film, and then they can work out a system. And I know those are more one-off situations, but it's tough. I don't have the easy answer, but it's a problem that I would love to work with a station on, I think we could do a lot to maybe help that, navigate that, and then maybe we even learn something through the process that we could open up. And that's what our site and our guides on the guides on our site and our book are all about. So maybe we could figure out a better way to do that.
Let's talk.
Okay.
Well, that's always going to be a challenge, though, because the kids want today's music, which is copyright. Randy, your turn.
I want to probe a little bit more on the talent release side, particularly in situations where I think, gosh, is this really practical? Is there such a thing as an implied consent? For example, recently there's been incredible demonstrations in the streets, right? We were out there with our crew, and there was certainly group shots of people chanting and whatever. I presume, my God, you can't get talent releases from a whole group of people. Right. But of course, a lot of people want to come up and say, oh, sure, I'll make a comment to you on camera, that type of stuff. And I've seen television news crews do these kind of things. They're not sitting there with somebody passing out talent release forms and pre-signed it. Is there such a thing in situations as an implied consent?
Well, there are other state law exceptions even in California that relate to news reporting, but it's something where we have some guides on our site about when you can video record and when you can publish those recordings. And no, absolutely, there are situations where people don't get releases, but I think that it's good before you're going to be going out to an event to kind of understand what the rules are surrounding that. I think that portraying people accurately, it goes a long way. Making sure that you're not sort of, putting them in a false light. That means, sort of associating them with something that it doesn't have anything to do with what you originally recorded them for. I think being very careful in those situations. If you do end up in those situations, I always advise people to stay away from the advertising and marketing aspect with those people's images, right? That person shouldn't become, the person you don't have a release from shouldn't become the poster for that work. It shouldn't become the advertisement for that work. You need to be pretty careful about that. And I think before you go out and you're recording, it's good to at least look at some, we have a chapter in the book, we've got a guide on our website about when and how you can record in a way that tries to stay within the boundaries of the law. But sure, there's some flexibility there, and there's a lot of recording that takes place without.
Most of us are doing things that are militantly non-commercial, so there's not going to be any type of sales involved with that. So it's really just like we want to share with the community what people are saying out there on the streets that you're seeing.
Yeah, is there ever an opportunity where it's a public event, people have put themselves in public purview, and you put yourself there and it's out there? I'm still prohibited from recording that?
Well, no, I mean, there are exceptions and there are reasons you can record people in public, but I think that my point is, if it's a reasonable situation to get a release, do that. If you're setting up a recording area and you plan to be recording there are also ways to set up notice in the space. I know we worked with a production that was recording in one of the trolley stations in San Diego, and we had to advise, we talked to them, of course they're not going to be able to get releases from everybody walking by, but there were signs put up and there was notice given about recording. And so where you can do those two things, great. And then in the other, there are other situations, and that's something I think to just consult to know what your rights are before you go out there, and to consult with somebody before you're publishing that. Yeah.
We'll go in the back.
Yeah. One quick comment about music. We have a music library license. It's very large. And one of the things we can search for when there's a pop tune request is in the style of. And sometimes we'll use a licensed piece of music that sounds like some pop tune.
Who are you using for that? I'm sorry, I was just curious.
Using FirstCom.
FirstCom.
Yeah.
Okay.
They're very large, and they have educational. They're like, if CBS has their license, it's about $50,000 a year for the same license that I get for $1,500 a year as an educational. So it's an awesome library. Question.
Yeah.
I'm just curious about this gentleman here with the camera. Should he be getting releases? Because he's not with CMAC, and I'm just curious about the circumstance here because of what we're talking about. I'm not trying to attack him.
Well, yeah,
I'm just curious about like the content that's being presented here. It's being recorded by CMAC. Is it cool that someone's here recording the same content?
It's pretty common for conferences to get speaker releases from folks who are speaking. That's a pretty common thing. Not all conferences do it. Some conferences do, some conferences don't. I'm at a conference next month that sent me release and was very clear that it's going to be used in certain ways. Because I guess, not to get too specific, but I guess I'm not, because it's my own case, so I can discuss it. But, in terms of, not to mention not only the likeness, but there's some copyrighted content, I guess you could argue too, and the presentation of that.
We do a lot of these kinds of...
Sure. The smart thing is, and I've worked with conferences of scientists and things down in San Diego that we've worked with that record everything and then make it available online. And we've worked to provide them with releases and a system that they can feel comfortable just giving their attendees maybe a 1-page, 2-page release that explains to them a little bit about how it's going to be used. And it's good practice.
So would that practice also extend to the people in the audience as well as the primary speakers?
I don't usually see that with the audience members.
I think, so you've had your hand up for a really long time, and so have you. So if we could go, it's two first, yeah.
I would like to use videotape deposition testimony, and obviously those witnesses are not going to give consent to have their eyewitnesses used. On the other hand, I understand that deposition testimony is in the public record. What can they do with it?
It's a case-by-case situation. I think obviously there's going to be some really important reasons why you'd probably be able to reuse deposition testimony. But
and testimony of people testifying to committing crimes.
Right.
And I'd like to use that for documentary.
Okay. Right, and so we work with documentaries all the time, by the way. That's our bread and butter, actually. Social impact documentaries. People give us a list of clips that are used, and then we review that, help them understand what's a good fair use, what might need to be licensed, and what might be public domain. And so in that situation, again, fair use really is a case-by-case situation. Offhand, it obviously, things that are in the public record, I think, things like that, a deposition testimony probably are going to have, without looking at it, but still, are probably going to have a good fair use argument if you're using it to really tell a story.
I actually own it.
Okay.
So I'm not concerned about using something someone else owns. I'm concerned about publishing the likeness of someone testifying to a crime.
Okay.
And I would blur out the face so that...
That's a specific situation that we've discussed that with you, and your attorney would work on that.
Let's go right here.
I'd like to hear an explanation about the fair use. I totally get that as far as using it for fair use. My question actually has to do with when we create stuff as an access center, because we create stuff in an original form. How do we make sure that when we do put it on YouTube and we do put it on those places that it's protected? Is it automatically protected? Is it one of those, some of the, that's what I kind of wanted to hear a little bit more about. How do we protect the stuff that we're creating in our access centers? Because everything that we have at Access Center now is non-copyrighted. There is some fair use stuff, but that's for our channel stuff.
And I probably glossed over probably the most important point, one of the most important points about copyright law. And I did mention it quickly, but as soon as it's fixed in a tangible medium, right, that it's, as soon as you've recorded that video, it's protected by copyright law. And so then at that point, that's when you're saying to YouTube, oh, we give you a non-exclusive license to use this.
So I don't have to take that video and get it licensed?
The only exception, though...
It adheres in the work automatically, right? So as soon as you make the work, the copyright attaches to it. The exception we discussed was registration as a prerequisite to bringing a lawsuit. But registration, I don't believe is a prerequisite to sending a takedown notice.
No, of course.
If you upload your video, say on YouTube, and someone copies it, doesn't make a fair use of it, uploads an exact copy of your video, you want them to take it down, you can send a takedown notice.
Absolutely.
as the copyright holder.
Absolutely, but additionally, I want to revisit what I said during the program though, which is, or during this talk, which is that if you have something that's really valuable, let's say you're licensing it out all over the place, or it's a very valuable, lucrative piece of video for your company or your channel, just thinking about registration is really smart, because if you're starting to see it pop up all over the place and you're concerned about that, if you have any, yes, you can set a DMCA takedown and that could do the trick, but if for some reason it's being infringed all over the place, for an attorney to ever work with you, you do want to go and register that. And you need to be registered before the infringement for you to get those benefits, or within 90 days of publishing. So just want to make sure that's
I think we have time for 2 more questions. We'll go here.
Okay. Quick, very short background. I had a basic class in 1976 on copyright when I was in law school. And I went to work 35 years for the state of California as a state civil service workers' comp lawyer, totally different area. Now I've come back and I'm a producer for CMAC here. And I'm getting back to what I was doing before I was in law. When I produce, this Digital Media Copyright Act is, as my contracts professor would have said, a whole nother zoo. So I probably am going to want to talk to a lawyer sometime who's in copyright, not in workers' comp. What's it going to cost me to get just the basic information about, hey, this is my idea, this is what I want to do with it. How do I not run afoul of the copyright law? I'm a retiree on a straight state civil service pension.
So there are copyright lawyers who do offer pro bono services or services to folks on limited means. You can call or write to New Media Rights. You can call or write to our legal intake if it's one of the issues we work on. We can either find you an attorney in-house or refer you to one of our cooperating attorneys, or if it's a question that's more in New Media Rights' wheelhouse, you guys provide all your advice in-house?
Yeah, we have 2 attorneys in-house, but yeah, we often share, clients come to us from EFF, we send clients the EFS list. The other thing I would mention is, on our website, we've created this IP clinics list. For not every state, but most states in the country, there's been a really nice blossoming of, there was only about 5 or 10 clinics about 5-6 years ago, and now there are almost 80 or 100 clinics that kind of do IP and entrepreneurship. And so wherever you are, especially in California, but there are a lot of school clinics. I mean, I know Berkeley has one, they have one out at the Harvard Cyber Law, but those have been around for a while. There are many, many others now. In fact, and ours runs out of law school in San Diego, California Western. I think there are a bunch in LA who do it. I think USC has one. And so there are a bunch of clinics that also offer support for a very reasonable price. You're never going to get all 3 things right. You're going to get it done well, and you're going to get it, you're going to get it done well, but it might, it might get it done for free, but it's going to take time, right? So it takes a little bit longer with clinics, but the nice thing is that there's a whole new generation of attorneys, law students who are being exposed to this area of the law, being exposed to public interest practice, and that's the whole reason I started the program that I started. And frankly, if I could, we have to turn away a lot of work, to be totally frank, and if anyone wants to work with me on that down the line, I'm happy to, but I turn away, we get 60 requests a month, I'd say, for legal services, and we can only take a tiny fraction of those. I'm sure that the EFF gets a ton of requests because I see them come through a lot too. I think there's a lot of need in that space to grow the network of kind of media law, copyright law attorneys. I think we need even more work supporting folks, because there's a lot of demand, and I'm willing and interested to work with anybody who's interested in growing.
Is this going to become more complicated and more entangled in the days ahead, or are we going to get to a point where it's much simpler and easier to maneuver through this?
I don't see it getting a lot simpler.
I mean, we started with a really short copyright, like the initial Copyright Act was really short, and then every subsequent Copyright Act has been exponentially longer and longer, and now it's like over 200 pages. So I don't really see that going backwards. We'd have to get rid of a lot of parts of the law.
Before we wrap up, I want to give Art and Carrie an opportunity to give you their contact information. I know there's going to be follow-ups, so, you know, Art, if maybe you could give them the address for New Media Rights and let them know.
Behind you. What I'm going to do quickly is I have some cards here too. You can either, obviously you can go to newmediarights.org, newmediarights.org, and you can find our information there. You can reach me at art@newmediarights.org. The best way to, if you're submitting a legal inquiry, if you're submitting a request for legal services, please use the contact form and don't write directly. It just helps us get it in the queue correctly. And one other thing, I just wanted to say, I mean, I think that's a really good point, that people should know the history of this, that this was, copyright was 14 years, okay, for books, maps, and charts at the beginning of the country, and it's now life plus 70 for all sorts of things. And so there's an argument there. You can have the argument, but I really think it's legitimate for us to think in the future about not just an ever-expanding copyright law. Like perhaps, you know, it's amazing because we only give 20 years to scientific inventions. I mean, to leaps of invention, we give 20 years protection, but to creative expression, we give life plus 70. That's a long time to give that protection. There was a study, I think, from a couple years ago that was just fascinating, where books from the 1800s are more available than books after 1923. You know, books from 100, 200 years ago, because they're in the public domain, are more available than these books that kind of got lost and became orphan works in the 30s, 40s, 50s. So it's a fascinating area. I encourage you to not just, you know, reach out on your own questions, but to think about ways to utilize and exercise your right to fair use, and to also get involved in all these policy debates that are going on. I mean, I think, you know, we supported both the exemptions you were talking about with some direct evidence as a commenter, and either whether it's coming to us or EFF, like, I think both, all these groups would love to hear from you what you're finding, because you work with so many different creators. We'd love to know the problems that you're having.
And you guys are directly impacted by the way these policy debates resolve, right? If we get automated filtering for every online platform, it's going to be really hard to distribute your producer's work. It's going to be really hard to run your own website with your producer's work, right? So your voices in these debates are really important, and you know, that's a lot of what we try to do is bring those voices out and to help you guys find an outlet where you can be heard, whether it's
And Carrie, could you give us the contact information for the EFF?
Sure. So I'll leave some cards out here. We already have some issue pages out here for some of the other issues we work on, and some stickers, including laptop camera cover stickers. And I'll leave the business card for our intake coordinator, Amul. His email is info@eff.org, and he's the person you go to with your legal inquiries if you have them. And you can also get in touch with me for a limited period of time at carrie.sheehan@eff.org. I'm on the website.
You were talking about the difference between the length of time. Do you think part of that is scientists are usually just representative of individuals, where on the other side you've got Disney and Sony and these big corporations, and I would think they have but didn't Disney just change the copyright laws to protect some of their content?
I work on patent issues too, and there are big commercial interests in the patent space that do want to see patent terms lengthened, like pharma and biologicals. Like, they want to see longer patent terms. They so far have not been successful. Disney's been really successful at lobbying for extended copyright terms. And that's just kind of the story of a lot of our copyright laws, the success stories of various industry groups in getting provisions of the law written directly to their interests. Because for a long time, people didn't care. For a long time, copyright seemed like a relatively esoteric area of policy, and you didn't have the kind of public engagement that you see now, where you saw, you know, in 2012, the big internet uprising over the Stop Online Piracy Act, SOPA. That kind of thing didn't happen, you know, 20, 30 years ago, and so a lot of copyright law was kind of made behind closed doors. So that's kind of why you have these exceedingly long terms. Also, you know, a lot of artists' estates want to continue to profit off of the work kind of long after, in most cases, long after the work like exits its period of profitability, and long after the initial author has passed away, and long after the incentive that copyright provides would be even remotely relevant to the production of creative work. But yeah, there are contingencies in patent law that want to see a longer patent term, and there's certain ways that folks go about even kind of getting limited extensions to patent term. Now there's a thing called patent evergreening, but it's
It seems strange with that. I mean, it doesn't have to be, it's not even like a liberal conservative argument either. When you think about economics of it, I mean, studios and people that produce content for content industry, even those folks don't even, big movie studios, they don't think more than 10 years, 5-10 years out on their, because the money value of a dollar made 30, 40, 50 years from now is a penny on today's dollar. So they don't, there's not a lot of that, in terms of copyright law being about getting things created and getting things shared with the public, that incentive is there when you shorten up that term a lot. So it is a, I think part of it too is when you have a really strong, over time, two-party system, there are issues like intellectual property that sort of get, that you might not get other perspectives, right? You might have, there's, the entertainment industry or other industries that could be very much heavily involved supporting both parties, and then you don't get other perspectives on how things could be different because of that. So you get some capture there of the issue.
But it's not. But there's, there is a lot of opportunity to kind of make a difference in that space now. Like Congress does pay attention to some extent to when they get a lot of calls and they get a lot of emails, they pay attention. When people raise their voice, when people take action, they pay attention. So now that folks are more engaged in the process, I think there's a more of a fighting chance for a copyright law that's a little more friendly to fair use and users of created works, and that's not just kind of continual extensions of copyright holders' power.
Especially 1201 is a real opportunity. And,
That's a lot to digest. Carrie Sheehan, thank you very much. Art Neal, thank you very, very much. You folks did a great job.
Thanks so much for having us. And please take stickers, issue pages if you're interested in our work on privacy, government surveillance, computer hacking, patents, everything.